All right, folks, let's come back to order here and for our next topic item to discuss, which is short-term rental property. Miss Albie?
Yep. Good morning again. I'm going to go over the proposed regulations regarding short-term rental properties. What is a short-term rental? We have the definition of a short-term rental property as a residential dwelling unit that is used and or advertised for rent for transient occupancy by guests. Dwelling units rented to the same occupant for more than 30 continuous days. Bed and breakfast establishments, boarding houses, hotels, and motels shall not be considered a short-term rental. So again, this is a rental of a property for to the same occupant for less than 30 days. So anything over 30 days falls under a different classification. These are some definitions that we are adding into our zoning ordinance for boarding house, commercial establishment, hotel, and transient. I will not read those verbatim, but again, the keyword transient is any person who exercises occupancy or is entitled to occupancy of any room, lodging, or accommodations for a period of less than 30 continuous days. There are two types of short-term rentals. There are owner-occupied and not owner-occupied. Obviously, owner-occupied, the owner of the property permanently resides in the short-term rental or in the principal residential unit in which the short-term rental property is associated on the same lot. So they can have the same person, they have to live on the property to be owner-occupied. They can either live in the main house, or if they have an accessory dwelling unit or a carriage house of something of that nature, owner-occupied means that it is on, the owner actually resides on the property. Not owner-occupied is defined as owner of the property does not permanently reside in the short-term rental property or in the principal residential unit, which is the short-term rental property, is associated on the same lot. So not owner-occupied means they do not live, that is not their primary residence of the property. Key individuals when we talk about short-term rental properties, a host is any person who is the owner of record of the residential real property or any person who is the leasee of the residential real property pursuant to a written agreement for the lease of such real property who offers a dwelling unit or portion thereof for short-term rental. So the host is the person that either owns the property or leases the property. The responsible party is another key person when we talk about short-term rentals. It is a person or business residing or located within 25 miles of the short-term rental property that is responsible for addressing all maintenance and safety concerns. So that is the person that will be listed on the application, that if either the person renting the property as they stay has an issue, who they call, or staff. If we receive a complaint, we will contact that resident, that responsible party, as well as the applicant on the application. So general provisions we are outlining here in zoning districts in which residential uses are a permitted use, including legal non-conforming residential uses. We added that language in there because we do have some subdivisions when we had tiered zoning in the past. An example is Woodland Lakes. That property is zone C3 commercial, but at the time that development was approved, Oldham County had tiered zoning, so anything that was C3 and under, which included all the residential uses, was considered a permitted use. So those are considered legal non-conforming residential uses. So we had to add that caveat in there. We run into this also, some properties in LaGrange along the railroad tracks, even out towards 146 Singleton Lane area, we run into that as well. So this is saying that in zoning districts in which residential uses are a permitted use and the dwelling unit is the primary residence of the property owner, they can apply for a short-term rental permit, and that can be reviewed and approved at staff level. That's only if it is owner occupied. Item number 2 states also the same beginning, in zoning districts in which residential uses are a permitted use, including legal non-conforming residential uses. A short-term rental of the dwelling unit that is not the primary residence of the property owner is required to obtain a conditional use permit. So there'll be two types of requests. There'll be one that can be approved administratively for short-term rental of their property if they are they reside on the property. If they do not reside on the property, they will have to apply for a conditional use permit and go before that appropriate Board of Adjustments, which would either be Oldham County Board of Adjustments, LaGrange Board of Adjustments, or Pee Wee Valley Board of Adjustments, just depending on where their property lies throughout the county. Multifamily apartments or condominiums, the applicant must either be the owner of the property or the leasee. If it is an apartment complex and someone wants to put their apartment up for a short-term rental, the application must be signed by the owner of the property. So they must sign the application to allow the leasee to apply for a short-term rental. And it's the same thing. If someone owns, say they own an apartment, and why they would ever have an apartment and not be their primary residence, but say they don't, if it is not their primary residence, again, they will have to apply for a conditional use permit. No persons or entity shall operate a short-term rental or advertise a residential property for use as a short-term rental without the owner of the property first having obtained a permit through our office. Any advertising or description of a short-term rental on any internet website must prominently display the permit number for the short-term rental unit, or include an image of the permit or a link of the image of the permit in which the permit number is legible. So any advertisement, they have to either list the number or an image of their permit to show that they have that in place. Outdoor signage which identifies the short-term rental is prohibited. So if I decide I want to do a short-term rental and rent out bedrooms and stuff, I can't have a sign at the end of my driveway that says the Alvey House. The outdoor signage is not permitted. There shall be sufficient parking available for the host and guests and shall not create a demand on parking. No food shall be prepared for or served by the transient, to the transient by the permit holder. So you rent the room out and they basically are there to stay. You're not preparing meals or anything of that nature. If you do, that somewhat turns into a bed and breakfast, because then you're providing meals to the people that are staying. The principal renter of the short-term rental unit shall be at least 21 years of age. The maximum number of occupants permitted on a short-term rental property at one time shall not exceed more than twice the number of sleeping rooms plus 4. All the research that I did, this is 95% of them came up with this calculation. So an example would be if you had a 3-bedroom house, you could have 6 people plus 4. So the maximum occupancy that you could advertise and rent your short-term rental out would be for 10 occupants. So I'm assuming that they think that people may sleep on the couch, or they have pull-out sofas, or what they're going to do for that. Simultaneous rental of a short-term rental property to more than one party under separate contract shall not be allowed. So you shall have one contract at a time. If you have 3 bedrooms, you can rent that out to all 3 bedrooms. You can rent 1 bedroom, but you can only have one contract at a time. So that means that you can't rent one to me, one to Chairman Jeffries, and one to Ms. Fox under separate contracts. You can rent all 3 under one contract, but you can't have separate contracts for the same rentals at the same time. The name and telephone number of the local responsible party who shall reside or be located within 25 miles of the short-term rental shall be conspicuously posted within the unit. The responsible party shall answer calls 24 hours a day, 7 days a week for the duration of each short-term rental period to address problems associated with that rental. A clearly marked evacuation plan is to be posted on the premise. Permit holder shall be responsible for maintaining proper insurance coverage on the short-term rental property. The permit holder shall be responsible for collecting and remitting all applicable room, occupancy, and sales tax required by state law and Oldham County. So they will be required to collect all the applicable sales tax and transient room tax as well. Each short-term rental shall be in compliance with any currently applicable laws and regulations of federal, state, or local governments, as may be amended from time to time, including but not limited to laws or regulations on non-discrimination, zoning, building, safety, property maintenance, health, sanitation, fire, electrical, plumbing, mechanical, and other applicable laws. For the application side of it, the permit application shall verify by affidavit that all of the information being provided is true and accurate, and the application shall include the following. They'll have to list the name, telephone number, and address and email of the owner, host, and of a person or business, which will be the responsible party. That will be required to be listed on the application. Owners applying for owner-occupied permit must provide 2 documents giving proof of occupancy. So if they're applying for owner-occupied, they have to provide that. I'm not going to read all of those that are on there, but those are the forms of identification to show proof that that is their primary residence. A floor plan of the residence showing the number of bedrooms and location of smoke alarms. The floor plan can be hand sketched, and floor plans shall show details of all levels of the house and attached structures, location of windows, and required smoke detectors. A statement that the applicant has confirmed that operating the proposed short-term rental would not violate any homeowners association agreements or bylaws, condominium agreements, covenant codes and restrictions, or any other agreement governing and limiting the use of the proposed short-term rental property. This is key because we do have some developments throughout Oldham County that do not allow rental of the properties. So we've already started a list because I've had some people that have contacted me and said, well, my subdivision doesn't allow this. We've researched their deed restrictions, and sure enough, they do not allow it. So myself and Brooke will be the only ones that will be issuing these. So we've started a list of subdivisions. So if someone comes in that particular subdivision and wants to apply for a short-term rental, we will not issue them a permit because it goes against their CCRs. Expiration and renewal of the permit. No person, firm, or corporation shall own or operate a short-term rental or on any premise within Oldham County unless the short-term rental has been registered annually with the Planning Development. The permit shall expire December 31st of each calendar year and is the responsibility of the owner to renew the permit. The renewal permits, they'll have to payment of renewal fee, a statement verified by affidavit that includes all the information required in the application under item C, and the short-term rental continues to be in full compliance with all applicable laws, including the payment of all applicable taxes. So if someone comes in and they're renewing their short-term rental application, staff will verify through the county treasurer who collects the transient room tax, the bed tax, and to confirm that they have been remitting the appropriate taxes. A short-term rental permit shall not be transferred or assigned to another individual, person, entity, or address, nor shall the permit authorize any person other than the person named therein to operate the short-term rental on the property. Denial or revocation of the permit. Upon the filing of a complaint regarding a short-term rental permit, the code enforcement officer shall notify the permit holder in writing or by email of such complaint and follow the process as outlined in the Oldham County Nuisance Ordinance. If the property is subject to 2 or more substantiated civil or criminal complaints, the planning director may revoke the approval. Any denial or revocation of short-term rental permit may be appealed to the appropriate Board of Adjustments as administrative appeal. If the property insurance lapses, the Oldham County Planning Development shall have the right to revoke the permit. And once a short-term rental permit or short-term rental property permit has been revoked, no new permit shall be issued to the applicant for the same property for a period of 1 year. Again, I breezed through that pretty quick. Jim, do you have anything to add?
By way of context, again, currently, first of all, Airbnb is a brand, like Kleenex is a brand of facial tissue, Airbnb, but that's what we're really talking about with short-term rentals. Any of the short-term rental brands are subject to this. We currently don't have any standards at all. This, again, doesn't, somebody said, oh, you're allowing this to happen? No, only if somebody wants to do it here. Now we're proposing standards. I want to say that Amy did a lot of research on this, and I think she did a great job of putting together this proposal. It's very detailed, and even the application, which is not part of the ordinance, is prepared already, should this move forward. The other thing is, that I want to point out, planning and zoning won't collect any of the taxes. This again is just a land use. The short-term rentals is a land use, and we don't have any responsibility for collecting any of the taxes or enforcing that. So
Okay.
with that, you can open
All
it
right,
up for
thank
public comment.
you all both for that presentation. Now we'll open it up for any comments or questions, testimony from anyone that is here. Anyone want to have questions? Yes, ma'am. Get you to come forward and we'll get you sworn in, Ms. Buckler. Ms. Fox, if you would swear her in.
Good morning. You solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And before we get started, let me just say we'll allow you, 10 minutes to make a presentation or whatever. If you need the full 10 minutes, fine. If you don't, then, 10 minutes is what we've set up as far as the time limits. Okay. And so if you would, just name and address for the record and what you're here or who you're here representing or whatever.
Kim Butler, Executive Director of Oldham Tourism. We're at 7204 Highway 329 Crestwood, across from Starbucks. I just wanted to offer some feedback on this particular issue from a tourism standpoint. We do, as tourism, collect the transient room tax for hotels and bed and breakfasts. And for 4 years, we have worked on this issue. So we have several properties that are short-term rentals that collect and submit that tax. One thing I want to be clear of is the short-term rentals, they collect the tax from their individuals. This is not a tax that comes out of their pocket. This is collected just like the sales tax and a 1% transient tax. In our county, it's 3%. The purpose of the commission is, just for your information, is to promote what we have in the county. So our interest in this particular subject is not so much the tax as much as it is the consistency. Because we have 5 or 6 properties that currently collect this tax. And from where we sit, if they collect that tax, then they're in compliance with us, and our job is to promote. So we promote overnight stays in the county because we want people to come and spend money in the county in our shops and restaurants. So the best way to do that is to have them spend the night and then be here for 2 nights. So this is really important because for the 4 years that I've worked on it personally, we have gotten those properties in and they want to be promoted in our marketing materials and on our websites. On the online websites like Airbnb and VRBO, they hide that contact information. So there is no way for us to get to them to let them know they need to be collecting a state sales tax by law and countywide, the transient room tax. There is no way for us to contact them to let them know they are not in compliance. And if they don't have a business license, or in this county, they're not obligated to get a permit, a business permit of any type, there's no way they would know that. So that's the other thing. I've written articles from tourism since July last year, and I've gotten calls back from that. But for example, there was a property just last week who called and wanted to set up a meeting with me to talk about the brown tourism signs in the county, and they wanted a sign. Well, as it turned out in that conversation, they would fall under the short-term rental, and how they explained it, they didn't qualify for a brown sign, but that was just the reason for the conversation. And as it turned out, I sent them to Amy because we now have a process we didn't have before, and we found out that they're not even zoned for that. And they're a retreat that has been in business in the county for 3 or 4 or 5 years, operating not knowing they weren't zoned correctly for that. So in these properties, if they pay that transient room tax, then as tourism, we obviously promote them. But there was no way before this to know whether they were zoned correctly or not. So we could be promoting a house that was not permitted in an HOA. Or we get calls, for example, people who stay in these types of properties, they stay for experiences rather than stay in a hotel. They want a unique experience. I get calls all the time for people asking if I have a home rental with a river view of the Ohio. Well, I don't, because they're not in compliance with me, but there are 4 or 5 in Oldham County that are on the Ohio River that would be fantastic properties for us to promote if they met, if they were correctly zoned for that. So We do collect that transient tax, and in our case, we were talking about collecting the county and state taxes. In October last year, just for your information, the state started collecting their own taxes from those properties, so it comes right out of their listing prices. That transient room tax in Oldham County is for marketing those properties, so it's not like we're saying, we don't want you to be here. We want to promote them, but we want to know that they're zoned correctly and our T's are crossed and our I's dotted when we promote them, and we're not sending them to some place that is not zoned correctly for one reason or another. So I just wanted to give you a little feedback from somebody who does collect that tax, and it is our job. And it is our job to promote those, and we do want to promote those because it adds to the experience of people being in Oldham County. So I just wanted to kind of give you a little bit of information of how another organization in the county is affected by this, aside from the zoning aspect of it. So,
Okay. Thank you very much.
thank you.
Anyone else? Anyone else? Yes, sir, Mr. McAuliffe. Same thing, get you sworn in and we'll get your name and address.
Greetings, Bob McAuliffe, 10607 Sleepy Hollow Road, Prospect.
Ms. Fox, I'll get you to ask him to, or be sworn in.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Okay?
Was the other testimony sworn in?
Yes, she was.
Okay. I didn't see. Okay. Well, I'm here because of a unique situation as well, because my property in the past and currently I have offered it for use limited number of times through a website, and so also what I guess really, and I really didn't prepare today. I haven't been part of all these things, so if my testimony is a little broken up, please excuse me. But I guess two things. One, Oldham County is approximately 200 square miles. LaGrange is 29 square miles. It's our most dense area. I'm not sure we got a problem in the county. I'm not aware that, I think my particular case is the only case where there was a complaint and code enforcement against me and my property. A complaint was brought. Now, it turned out that that case was dismissed. After the code enforcement, after it was appealed to circuit court, that case was dismissed. We don't have a violation. It is allowable use in this county. I just heard testimony that they were not zoned correctly. We don't have any issues on people offering their homes on an occasional basis to people that travel in from out of town. I have a guest that has stayed at my home for 3 Christmases. For the whole week, they come from London. I've rented this year twice that my property has been rented out. Obviously, anybody that owns a home is very careful how you and who you have use your property. We're not some, and then, I think there's a definition. This is important documentation here that you are trying to now place into your responsibility and put restrictions in. And I think you need to go through it carefully. Unfortunately, I was not able to attend the last hearing, so I would have offered some of my comments with that to them. But I think I just will go through some highlights. This is an overreach. People, and I think in general, let me just say this. If someone purchases a home and that's all they're going to do is rent it every single night, that's a different situation. So I think you have to scale this. You have to look at this in terms of what are we looking for? The largest in Oldham County, and I would have had a lot of handout material, but in Oldham County, to my knowledge, there's less than 100 pieces that are offered on VBRO or Airbnb, and you have to drill down on each one of those. Every single one of those is going to be grandfathered, non-conforming. So whatever you do, they all are allowed. You can't restrict them on a use that they've already had. So I think the staff needs to have gone through a much more detailed, factual research to look at who are these people. And then there may have been a reach out to those. Back to the county, there's one property north of LaGrange here, and it has the highest number of reviews. That kind of tells you that it might be the highest use by, short stay, and it's 235 times. 235 times, and that's massive compared to all the other listings that I've researched. Mine, 14. That's how many people have stayed in there in over 3 years, okay? It's a wonderful experience. I got into it because before the computer was around, I would take travels out to the Southwest, and I would stay at somebody's home. It's much more fun. It's a great experience. You get all the details, and so it's just a lot better experience. My travels to Europe, stay not in a hotel, stay in a short-term stay location. So in Oldham County, to me, there's 2 properties right here that I saw boarded up in downtown LaGrange. 2. Those are struggling buildings. We want to keep those around. We got City Place, wedding venue, Rawlings Company. Why do we want to make it more restrictive? Why can't we let those second floors of those be short stay? Let them, if there's a tax, pay the tax, who cares? But let's not put all these restrictions in. But get those properties as much money as they can to be viable. We'd be much better to promote, to take some of these buildings right here, and you got a wedding venue right out back. And some of those people may not, the families, hotel rooms aren't a great place for wedding venues. You got a room, and another room, and another room. How about a house? Or a second floor of a building here. So I think it's just a big overreach. There's a lot of details. I got 4 minutes left. So we're a rural county. The piece that has 235, it's sitting on 80 acres. What trouble is it causing anybody? My property is sitting on 100 acres, okay, which is called part of Sleepy Hollow, and it was formed in 1922 as a resort. Articles of Incorporation filed 1933. And I have one of the last 5 cabins left. So now, the reason the neighbors had complained, but their complaint was based upon they've sued 6 other people and ran them out of the neighborhood. Okay, now I was sued because my property was listed. It's just in Google White Pages that my daughter lives there. So my daughter was in college, and they were saying she was a shareholder. So it was just this big 3-year lawsuit over shit, excuse my language, to harass me, to force me to go. So eventually Planning and Zoning chose to bring an action against me over that. So let me go through some of the issues. There is currently short stay it's a legal use. There's nothing wrong. We don't have to zone anything. Are we saying that there's an 80-acre piece of property and we got a second farmhouse out there? It's 2-bedroom, 1 bath. And now you're saying that you got to put exit signs up and direct people how to get out of the building. Do y'all really want to get into that? That'd be part of your regulations and enforcement? I think staff is busy enough for us to get away from some of her details in here. And then they say if there's 1 complaint, what's the definition of a complaint? Who's going to review that? There is no, what is the complaint over? And that they could revoke your right to use it. I think it's the other way around. We should be able to use it as a private property owner. You should be able to use your property how you deem fit until you reach the threshold at which time you become a nuisance to your neighbors. And so therefore, if we're going to pass any new zoning regulations, in my mind, frequency is going to be something you need to put into this and consider. What is it? Once a month? Is that too much? Is it, what is it? What is the frequency? So, there's no compelling evidence. When I asked staff of I was expecting a rash of complaints. The most complaint I heard was from Director of Tourism, that it's not a use that's permitted and we want money. Well, do you all feel that that's what a justification for planning and zoning to change its land use guidelines based on taxes? I don't think so. I think we're approaching it from the wrong direction. Meaningful, responsible, and then we're not, this is, we've pulled data and stuff. I met with staff. We pulled data and stuff out of a number of different regulations, but they're all been urban type settings. Bardstown, not in a 200 acre, we're not going to apply in a 200 square mile acre county. So I'm going to just quickly go through it, and I'm going to ask, could I have an extension of time?
Give you 2 minutes.
Thank you. There's no compelling evidence. And certainly I think that needs to be more engagement to the people that are in the county that currently are utilizing their property on an occasional basis, for short stay. I'm going to go through the proposed short-term paper. How did we arrive at you have to be within 25 miles? What is it? Arbitrarily? If it's an Oldham County property, shouldn't we restrict it to the boundaries of the county? Shouldn't we even be closer? I mean, what is that? Where does that come from? The general provisions, and then just in terms of separating out whether a unit is owner-occupied or non-owner-occupied and setting procedures down where somebody's got to go get a non-conforming use through the Board of Adjustments. I think that's too restrictive of an issue. No person shall operate, item number 4, no person shall operate an STRP, short-term rental. We need to talk about frequency. No advertising, can't display it on the internet, restrictive. That's all we're doing is going down here through here is restrictive. Item number 10, we're going to be reducing revocation of the permit if there is a complaint. What's the complaint? Clearly marked evacuation plan posted on the premises of a 2-bedroom, 1-bath house. What are we getting into that for? We're acting like this is a multi-story apartment building. The STRP shall be submitted with an affidavit, an application, an affidavit. It's overreach. Owner 2 documents providing proof of owner occupancy, overreach. Floor plan of the residence showing the number of bedrooms and where the smoke alarms are, overreach. So I think the real deal, and I see my time is, well, I have 2 more minutes after this.
Well,
correct?
now that was 2 minutes. You do have about a minute left, is what you, because you had about a minute.
Okay, all right. I think that before, just a simple way, and I also just want to make a note that there are exceptions to everything. There should be exceptions to everything. My property, built in 1922. It's been used as a summer vacation cottage with a separate bedroom in the front to be rented out for $5 a night, $6 a night since it was built. And all of those cabins were exactly the same way. Okay? So, and also I can only tell you that through circuit court, I prevailed. So you got to be careful. This is a very complicated thing when you start trying to be restrictive, take away people's property rights. And I appreciate the staff trying to address an issue, but I think first it's got to demonstrate to the community, not all, as well as you, that there's really a problem in the community right now, and we have to address this. And again, if it was the city of LaGrange, 29 square miles, it wants to deal with it, it feels like it has a problem, let's let it be dealt with on a local basis. Thank you for the extension of time.
All right, thank you, sir. All right, anyone else have any comments or questions? Okay, seeing none, I'll now ask the commissioners, do you all have questions or comments on this? Ms. Bonet?
I don't know if this was ever covered, but just for my curiosity's sake, the transient tax, how long has that been around in Oldham County?
1996.
How exactly is that collected? For example,
Let me ask Ms.
Yeah.
Buckler to come up, if you would, and she's the Director of
Okay.
Tourism, and so she could probably answer that.
so, I mean, you were saying that you all were collecting the tax. How does that work? Because I'm sitting there thinking, you know, the homeowner or the owner of the property is collecting the income from the rental. They then do a percentage check to you? They have a form, kind of like filing taxes?
There's a tax form where they calculate the money they've collected on rooms. They submit it to the county treasurer every month. Like February 15th, they would submit their form and taxes from January, the 15th of the next month, and they write their check and all of that to the county treasurer. The county government then writes the Tourism Commission 100% of that tax, and that is our budget to market the county.
So when you brought up the Airbnb situation, I mean, Airbnb doesn't own the property or keep the income, I'm assuming, I'm not real familiar.
Airbnb charges a percentage before when you rent through their website.
Right.
It's the reason they keep the contact information and all of that confidential,
Right.
so people don't bypass them. But they charge a percentage, and I believe it's 15%. They're 3 to 15% is what they collect.
Would it not still be the property owner's responsibility to calculate the same way any other short-term rental property owner would pay the taxes? I thought you had brought up an issue with Airbnb and the transient tax.
Currently, as of I believe it's October 1st last year, Airbnb specifically started collecting the state sales tax and a 1% tax for state revenue, automatically deducting it from the payment made to the short-term rental
Okay.
homeowner. So they subtract their fee plus the sales tax plus the 1%. And they do this all over the country. Kentucky was just brought into that.
Right.
So now they take care of the state taxes, but not the local taxes. So if there were business licenses or the transient room tax locally, they don't collect that. They leave that for us to collect.
They leave that for the owner of the property to be responsible to pay.
Correct. And the issue with that is, and has been, that we can't get to those people, to the homeowners, to let them know about the local taxes.
But if they had a permit, then they would be well informed to actually be paying
Correct.
those taxes.
Correct.
And with the permit number having to be displayed on internet advertising, once again, if the person has a permit, they would be knowledgeable and aware. Do they not submit photos to Airbnb to be shown with the listing? Could that not be one of the photos to cover that regulation?
Yes.
So the permit process is allowing us to educate the people that actually have the responsibility for the taxes and the permit
Correct.
number, I guess.
And the people that I have dealt with for 4 years, it's not like they're trying to get out of paying a tax or
Right.
doing the right thing. It's not that. It's that they don't even know about it. And really the only way to get in contact with them is to do a story in the era about it and how many people get the era without it traveling word of mouth. You know what I'm saying?
Right.
Renee, is there anything else that you,
I actually had a question for the gentleman, and then
Mr. McAuliffe?
I'll be finished.
Okay. Mr. McAuliffe, if you would come back up, she has a question for you also.
So in all the years that you've been renting out your property, have you been paying the transient tax?
I'm not aware of it, and nobody would be opposed to paying it. That's not an issue. The issue is, what I'd like to know is, how much money are we talking about countywide? What do we think we're talking about as we're standing here? Do you have any idea? You've worked on this for 4 years?
Mr. McAuliffe, it's not a
Well,
debate.
okay,
That's
then
not-
I'm
that's not
asking the
part of my
commission and
question.
staff, if this is a
Chairman,
tax-
if I
That's not
may-
part of my question.
Hold on.
If I may, this commission does not govern in tax policy. Tax policy is out of scope for this commission. We should not take this up as decision criteria.
You have any other questions, Ms. Bonet?
Yes, I'm sorry, I'll hurry. Why do you think that in having a permit process and requiring things like a diagram showing where the smoke alarms are and a limiting number of people being able to stay in the house, why do you think we would want that to occur? Why do you think that's a bad idea?
Well, what I think is bad ideas for planning and zoning to get in the middle of all of that, just as though taxes, everybody's individual home, if you're gonna rent it, you're gonna comply with everything that you're looking out for. You gotta deal with your insurance company, you gotta make sure that's happening. I only do it, like I said, this past year, I've only done it twice. It's for a very select group of people.
Don't you
And
think for
so-
public safety, it would be a good idea to have someone
don't think
sign off
I
and
don't
say
think-
that they actually do have the required smoke alarms for the safety of the people staying in that home. It's this simple process of getting a permit and doing the things that should be done for the safety of the public per common sense. And you can stop me if I'm testifying. But there are several properties that have issues. There are properties that have had drug use, needles in the streets, and I'm talking in
A little bit toward testimony there.
parties. There are issues. Not all property owners are as polite as you are in dealing with their rental.
If I may respond to those comments? My first thing is, what are the complaints then? You should list out every single complaint that you deemed is, and expand upon that in this language so that you rightfully are giving notice to everybody what is considered and could be considered a complaint.
That's in the nuisance
We don't-
All right, hold on.
ordinance. Yeah.
Any
I'm
further
done
questions?
after that.
Okay. Yeah, Mr. Douglas, do you have a question for Mr. McAuliffe, or just in general? Okay. Thank you, sir.
Does this new requirement also pertain to farmers, horse farms that have transit people come in and temporary stay as workers, their transit?
Not for workers, no. That's a permitted use through the agricultural definition.
Okay.
Okay. Any additional questions? Yes, sir, Mr. McWilliams.
Do we have any feel for issues that are created? Are there more issues created with not owner-occupied properties versus owner-occupied properties?
Mr. Urban, or?
Well, we don't have any statistics, and it would be nearly impossible to understand what it is because we have no registration at this point. But we do have a code enforcement officer who has responded to some of the complaints regarding short-term rentals. Owner-occupied, you would assume that they're in the house and along with the people versus somebody who is not on the property might manage the property a little better when they're owner-occupied. That's why when Amy did the research regarding a distance, you know, you got to remember that 25 miles puts you into Louisville, and that's an easy reach to come back and manage a piece of property. But most regulations have some kind of responsible party portion in their regulations.
May I ask another question while you're there, Mr. Urban? On the second page, number 8, this is for my own edification and amusement. No food shall be prepared for or served to the transient by the permit holder.
Right. Amy had explained that that then becomes more like a bed and breakfast than it is a short-term rental. And when you have a bed and breakfast, you have to get the health department involved in that food preparation area. And the intent of the short-term rental is for, you know, it does limit it to 30 days, but most of the time it's maybe a week at most, but certainly like weekends or overnights.
Now, I realize I'm splitting hairs here, but
And the key.
no food to me means,
They can prepare their own food.
Yeah, they can prepare their own food.
I understand,
But it's
but
not-
I couldn't make them a sandwich.
No PB&J.
We're not going to regulate that or no, but it's just, again, that then it requires health department being involved in their kitchen.
How much outcry was there, and from whom, if you can say, for this short-term rental property?
Well, let me
I'm just curious.
let me start.
If I understand part of it, I think it's good, and I think part of it is overreach too.
Well, let me start, if I may, Mr. Chairman, and then this will be somewhat responsive to what we've heard from the people who testified, but this is a land use issue.
Okay.
It is very similar to a bed and breakfast, which is currently part of our zoning ordinances. And I don't understand why somebody who has a business out of their home wouldn't be regulated in the same way. Major cities have created ordinances and other communities. I mean, Amy was able to put all this together because she did research and found all over the country, there are people, including locally, who have, communities who have created these regulations. And we have had issues with rental properties, not people who are there renting a house for a long term, but short term. And we have had code enforcement issues, and Ms. Bonet knows one of them in particular on the north side of the county, where the people didn't even live in the country. And it created parking problems, noise, partying, large groups, and the neighbors who live around these properties. You got to remember that these are single-family residences, and there's an expectation when a person owns a house, whether it's in a subdivision or just in a group of single-family houses, they have an expectation of the quiet enjoyment of their own piece of property. And when you start renting it out short-term, it could change that expectation. So this is not an overreach in my opinion, because again, I have an expectation that I'm going to at least have some kind of understanding that there's not a business operated in the house next to me or transient renters. These regulations actually level the playing field. Those people that want to have legitimate short-term rentals now have a standard. Everybody, if they're all registering and applying and going through, they're all complying with the same standard. Right now, when we get complaints, and there's one in Pee Wee Valley, that there's no standard. Not all applications are on large parcels of land. They're in subdivisions. They're houses here and there in the county. And I do want to say that they're also not grandfathered. We are currently dealing with another subject matter, which is event venues. A current trend in the country, and certainly here in the state of Kentucky and in Oldham County, is to make barns on properties into event venues. And the state even passed legislation that said, okay, wait a minute, we have to look at these things, because old barns are tinder boxes. You can't have candles and all of a sudden the place burns up because it's old lumber. So we are going back and actually creating conditions and standards for event spaces. And people that have these are coming in. One was in front of the Board of Adjustments just last week. So they're not grandfathered. If anybody really wants to have a venue for short-term rental, they should apply, whether they're in existence or not. And things like the exit signs and smoke alarms are, again, for public health and safety. You're changing the use group of your house when you're inviting people to come in, not as a guest for free, as a friend, but when you're renting it, it's a different use group. And I think that's what's important to understand in putting these regulations together.
And one more quick one. Sure. What, if I'm reading it correctly, if I have a room that I would want to rent in my home, I could not put a sign in my yard that said room for rent.
That's correct.
Okay.
Yeah, the advertising doesn't include being on one of the websites for a short-term rental. It just means that you don't put a sign on your property.
Okay. Now, what's the thinking between that and a realtor sign?
Well, realtor is
No, it's for sale.
It's for sale, and there are
Could be for lease.
in the sign regulations. There are requirements for realtor signs or for lease signs, and if you're in compliance with those, you can put one out. But what ends up happening, especially if deed restrictions or covenants don't preclude somebody from having a short-term rental, is all of a sudden you'd have a bunch of signs in people's yards with rental property.
Anything else, Mr. McWilliams?
Would you like for me to stop, Mr.
No,
Chairman?
no, no, you have the floor.
I know you would, I will.
Anyone else? Any other questions? Okay, Mr. Douglas?
Follow-up to Mr. McWilliams' questions. So this regulation would affect realtors, just like Mr. McWilliams said, that during the process of a sale of a residence, the sellers are leaving and they make some arrangements with the new owner and the realtor that they need temporary residence, and they decide to do a temporary short-term rental for 2-3 weeks in that residence. So they got to come in, do a permit, request that.
Well, if I'm hearing your question correctly, that sounds like a one-shot deal, and the answer is no, they don't have to do that. This is if they're going to advertise it as a regular venue for short-term
So that
renting.
we're just consistently saying advertise? Is that
Well,
what we're saying? I didn't
again,
read that as saying that it's advertised.
Transient. Right, transient rentals, not, oh, I'm gonna rent my property for a month because I'm in, waiting for my house to be ready or something like that. No,
So we mentioned that agriculture was exempt. How's that exempt,
well, your question was related to farm workers.
right? So how's that exempt if we have a rancher or horse farm or a farmer that has rental property and they decide to leave the transit to stay there for 30 days, less than 30 days or whatever to work?
It's a
Is
different
that
subject.
Different subject?
It is, yeah. It's
Okay.
for agricultural purposes, not for tourism and, short-term stays related to people traveling through the region. If I'm hearing your question correctly.
Well, I mean, it's usually generally transit people that come through to work.
Well, transient farm workers, you mean?
Yeah,
Different subject. It's agricultural related.
okay. That's all I need a
Falls
clarification.
under a different set of regulations.
That's what I
on-
thought.
Yeah.
Thank you.
All right, anything else? All right,
All right.
How does this work with the house swap for less than 30 days? If I'm going to, I'm going to stay in your place in Florida for 3 weeks, and you're going to stay in my place in Pee Wee Valley for 3 weeks. Does that, do I,
If they're a house guest and you're not
I'm not there.
charging them.
I'm not there.
No, but if you're not charging them, this is again,
Okay.
it puts this in the category of a business.
okay.
When there are contracts and there are business relationships on this piece of property that's zoned residential, that's what this is about. It's not about, oh, come stay at my house while I'm in Florida, or, people do house sitting. It doesn't relate to house sitting. I'd like to go to Europe for a year, but people stay in people's houses short-term to take care of animals or whatever might be there. That's not related. This is in relation to short-term rentals, typically through one of the websites.
Gotcha.
Yeah,
Thank you.
And again, this is an income-producing business.
Thank you. Thank you.
any other questions? Any further questions? Okay, we will now, as we have done, entertain a motion to recommend to the fiscal court in the 3 cities this language on short-term rental property. We have a motion to that effect. Mr. King?
Thank you, Mr. Chairman. I move for recommendation of approval of the short-term rental property proposal to the planning unit and the members of the planning unit.
All right, we have a second. Mr. Falvey seconds. Now, any discussion? Any discussion on the motion to approve? Okay, seeing none. All those in favor of recommending to both fiscal court in the 3 cities, Crestwood, Pee Wee Valley, and LaGrange, the language for consideration on short-term rental property signify by saying aye. Aye. All opposed, no. Okay, motion passes.
Mr. Chairman, is this motion binding on the city? They don't.
No, this is just a recommendation from us to them. They can completely change it.
Valley could opt out of it.
Absolutely.
Valley wanted.
If they can change it, so can fiscal court. So normally what will happen, fiscal court will hear this first. I'm sorry, we'll hear,
No, they
No.
didn't last time.
fiscal court will hear it first normally, and then the cities usually wait until fiscal court makes a decision, and then they will take it up, is what normally happens. So, with that, I hate to have to leave here early, but Mr. King has graciously said that he would finish up the meeting. We don't have a whole lot left to cover, but Mr. King, you might ask Amy, we do have one hearing, looks like, for next month. So at the end, we can get her to clarify that. So, thank you all.
All right, the next topic is maximum height regulations. We had discussions at the study review committee meeting regarding the 45-foot height limit. You'll see that in non-residential properties, in office 1 and 2, commercial neighborhood, and then all C1, 2, 3, and 4, the maximum height restriction is 45 feet. We recently had a case that came before the Planning Commission where a hotel was asking for a revised development plan along with a height variance for the parapet portion of the roof. And so that brought up discussion at the study review committee level, and Brooke had done some research in other jurisdictions and looked at just comparison of other height regulations. So that we are proposing in C2, C3, and C4, which in C2, C3, and C4, that is where hotels, motels, and convention centers are permitted uses. We're proposing to go from 45 feet to 65 feet, which is a 15-foot increase. And again, this is just in only C2, C3, and C4. There are no proposed changes in any other zoning district for maximum height. And that's
Right.
pretty short and sweet.
So, questions from the commission? Please.
Yes, sir.
I'm assuming that an applicant can still apply for a variance.
Yes, sir. Yes, sir.
Anyone present? Mr. Archer, you have anything to provide input on this today? Okay. All right, so, well, that was pretty simple, Amy, thank you.
If they all were that easy.
All right, we should have kept Kevin for this. He could have gotten some closure. All right, the chair will entertain a motion to recommend approval of the maximum height regulation proposal to the members of the planning unit, which include Fiscal Court, LaGrange, Crestwood, and Pewee Valley. Ms. Bonet.
May I just say so moved?
You may. Thank you. I have a motion on the floor and a second. Mr. Douglas, thank you. Any discussion? You guys are looking done. All right. Then we'll move to a voice vote. All in favor of the motion, please signify by saying aye. Aye. All opposed, like sign. Motion carries.
Okay, the last subject is away from the zoning ordinance. We're moving into another regulation, which is the subdivision regulations. So we are looking at Article 3, subdivision consideration process. Section 3.1, this was just some grammatical cleanups and stuff in the first paragraph. And then there is a table that outlines what divisions it's applicable to, action taken, and the steps that are required. So the first one just says, it said division not of a subdivision, so it was kind of misleading of what it was. We didn't really know what that meant. So we added it to be called easement plats, adding or removal of any easements of any type. And then what the steps that are followed, which is steps 1 and 6 on there. And again, the steps are coming here on the next slides. Section 3.2, potential actions. The paragraph that's in green had been moved from lower in the body of the text, so we moved it up, and then we also struck the portion that says when requested 1-year extensions of approval may be granted by the commission. This is where we have our internal policy through the Planning Commission regarding extensions of expirations. So this is where we're outlining that they're allowed to have 1-year extensions. Right now we do 2-year extensions, but now we have proposed this to say when requested 1-year extensions of approval may be granted by the commission. In granting the extensions, the commission shall have the right to require amendments to the approved preliminary plat when it finds that applicable ordinances and regulations, land use plans, local land uses, or development conditions have changed since the approval. And then it says approved final plat shall be recorded. It previously said 6 months. Since I've been back in county government for the last 7 years, the stamp that I stamp on every minor plat says shall be recorded within 1 year. So we've been stamping it for that says it has to be recorded in 1 year, and the reg always said 6 months. And even previous to that, it was always a 1-year rule. from the time that Jim signs off on a minor plat to either consolidate land, subdivide land. They have 1 year. So we're just kind of updating the regulation to what the practice has been for the last 15 years or so. Postponement, that section there, it says the commission or designee may postpone its decision pending further study of the plat. It says, but in no event shall the decision be postponed more than 90 days from the date of the filing. At any step in the process as outlined here without the consent of the developer can request postponement beyond 90 days. Postponements are regulated through KRS 100. So of the decision making of the time from when it is applied to the time that a decision has to be made. So we just struck that out, and it just all, like, again, that's all regulated through KRS 100. The second is just a grammatical to put amendment before revocation. This outlines that says that any plat, any minor plat or consolidation plat at the discretion of the administrator, that he can approve that, or it can be referred to the commission. So in the event that staff receives a minor plat or a consolidation plat or something of that nature, we had one that was over on Halls Hill Road that was a mess, and so staff was not comfortable with reviewing that and signing off on any of that, and this just clarifies that it says, or it can be referred to the commission. So that way it becomes a public process. Preliminary application meeting, there was no change in that. Preliminary plat, pre-preliminary plat under step 2. This is, previously it says that talks about neighborhood meetings. It says at this stage, a meeting with identified neighbors is required to facilitate the identification of potential resolution of community concerns for all subdivision plans. Previously, it didn't outline whether a neighborhood meeting only had to occur during a zoning map amendment. So staff felt that it was important, if someone had a large piece of land and we're going to put 200 homes on it, that it was important to require that developer to have a neighborhood meeting with his adjoining property owners. So any subdivision plan that comes through, regardless if it requires a zoning map amendment or not, will be required to have a neighborhood meeting. And then the next paragraph, or next area there, it says the subdivider will need to provide the commission staff a list of first tier, which is adjoining property owners, and second tier property owners. Those adjoining the first within 500 feet are to be notified if the plan is part of a zoning map amendment. We had a developer that had questioned the wording of this, and so we tried to make it as clear as possible when first tier and second tier are required. So second tier will only be required if it is part, which is anyone within 500 feet, if it is a zoning map amendment. Preliminary plat for subdivision or for commission consideration. That is just says the commission shall hold a public hearing as part of the consideration of any major preliminary plat. Before it just said preliminary plat. A major preliminary plat basically would be a subdivision plan. So this is saying in our regulations that we will require, even if the property is zoned appropriately, they are not asking for any variances or waiver, it will be required to hold a public hearing through the planning commission process. Any plat that involves a request for waivers or any deviation of the substantive requirements of these regulations or proposes development of an environmentally sensitive area as defined herein is required to have a public hearing. That's pretty standard, that says that if they have to have any waivers or variances, they have to have a public hearing through the appropriate body. And then it says any minor plat complying with the requirements of the regulations as determined by the commission staff shall not require the holding of a public hearing. So if it is a simple minor plat, division of land, consolidation of land, no variances or waivers are needed, no public hearing is required. Construction plan approval. This is the paragraph that I worked with the county engineer on to tighten it up a little bit and update the language. It just basically says upon approval of a preliminary plat and prior to construction of any physical improvements to the subject property, a subdivider must submit a soil and erosion control plan simultaneously with the construction plans as required by local, state, and federal agencies, providing technical data concerning the location, type, and quantity of specified physical improvements and or infrastructure. Construction plans are to be reviewed and approved by the county engineer. The soil and erosion control plan must be in place before any earthwork may begin and shall comply with all county ordinances. And then this was the one that kind of started the whole ball on this section. It says, a subdivider wishing to divide property in Oldham County shall, upon receiving all prerequisite approvals, submit a final or record plat for consideration and action by staff. It currently says, if the required requisite final or record plat conforming to the approved preliminary plat is not submitted for review and approval, whether in total or in phases within 3 years of the date of the approval of the plat, then the plat is considered void and must once again be submitted as a preliminary plat and come back to the Planning Commission. So this defeats the whole purpose of capacity planning. So this is saying that that 199 lot subdivision has to go to record within 3 years. So this is in total conflict with the whole process of capacity planning and phasing. So we struck that on there because, again, even when we were allowing 40 at the time when it was approved, 199 lot subdivision could not physically be done within that 3 years. So again, this just defeats the purpose of capacity planning, so we removed that from the language. Again, step 6 talks about recording the plat. That is where we removed the 6-month language and added the 1 year back in because that was what the current practice is. And that is all that I have on subdivision consideration and process.
All right, thank you, Amy. Mr. Archer, since you're my only member of the gallery today, we'll give you a bite at the apple. Nothing? Okay. Anyone on the commission? Discussion, questions? There being none, the chair will accept a motion for recommendation of approval of the, what do we call this, Amy?
Article 3 subdivision consideration process
Article
of the Oldham
3.
County Subdivision Regulations.
As Amy stated, the recommendation of updates to this provision and recommendation to the planning unit. Looking for a motion.
So moved, Mr. Chairman.
We have a motion on the floor, Mr. McWilliams. A second from Ms. Bonet. Discussion. Crickets. Chair will accept we'll go through a voice vote. All in favor, please signify by saying aye. All opposed, like sign. Motion carries. Amy.
Okay. That is all that we have on the agenda for today. Staff will take these recommendations and move them to fiscal court, and then on to the legislative bodies from there. If there is any substantial changes and stuff to the proposed regulations, those will go back to study review, start the process over, and come back to you guys. We will have a meeting next month. I've already received an application for a cell tower over off Highway 42. So we will have that. It is the first item on the agenda right now. Filing deadline is tomorrow. As always, I will send out an agenda once we have one set of what we will have. But we will have a March 27th meeting.
Very good.
That is all that I have.
All right. Mr. McWilliams.
Mr. Chairman, just would like to thank staff and Mr. Urban, Amy, Brooke, Ms. Fox, whomever else was involved. I should have never started with names. I'm sure I'm left somebody out. But anyway, there was a tremendous amount of really, really good work that has gone into this. And we're so fortunate to have the people that we have. And when things come to us, we just don't have to reinvent the wheel. We may get to tweak it here and tweak it there, but it's not that way everywhere. So to you guys, I think I can speak for the entire commission. We're appreciative and thankful, and good job.
Thank you.
Thank you. Appreciate the mention. My name should be at the bottom of the list.
Wherever
It's
you
really-
want to put it.
All right. If nothing else, then we will stand adjourned. Thank you.